More and more people are considering wealth preservation across generations. For many of these glass ceiling shatterers who create wealth out of nothing, the thought of having descendants squander their sweat is enough to make them consider ways to keep and grow wealth, and hopefully in perpetuity. One such way is through the creation of trusts, and that is our topic today on Law Express. My name is Noella Seidu. Stay tuned.
Inshirabayao Sumpa Otre is a private legal practitioner who enjoys playing chess and traveling at his leisure time. Theodore Kweku Albright is a private legal practitioner who loves cooking, travel, and has a deep appreciation for music and art. Noella Seidu. She's a private legal practitioner and a consistent member of our 3-lawyer panel on the show every week. She also doubles as the host of the show. She likes to play tennis and read.
Okay, so the conversations around trust is a very interesting one, and the history is closely related to our inheritance of the common law from the English. Mm-hmm. Primarily, it was a question of when knights were going to war and wanted to leave their estate or their property so that when they came back, they could have it. So they would usually pass the legal title or the right to the property to somebody else, mm-hmm. but reserve the equity of it to themselves, or the beneficiary interest in it to themselves. Now, the practice evolved in a way that it was recognized in the courts of chancery, as they call it, which is basically the equity or the fair arm of the law among the English. Yeah. Now, we have had to borrow that antecedent, but primarily the definition of what a trust is, depending on who you're reading, mm-hmm. it can be convoluting. Yeah. But 3 essential things. You need somebody saying that I'm the absolute owner of a property. Yeah. I'm giving that property to a third party, or in some cases myself. Yeah. Which person is a trustee. Yeah. And that person is supposed to manage it or take care of it for the benefit of a third party. So usually there are 3 people. It's an agreement, or it's a device that the owner gives a legal right to the other person, while the equitable interest rests in the other party. Yeah. So primarily, that's sort of the foundational understanding. Any instrument that gives an absolute legal right to one person to manage for the benefit of a third party.
So it's more or less looking for a caretaker to manage your assets for the benefit of either others or you.
That's absolutely correct. I give you my mug. I'm the settlor. Mm-hmm. I give you the mug to hold on to it and hold it for me to use as and when I need it. But it might not just be me. It might be me and my spouse and my children. So you can use that example. Mm-hmm. The only time that becomes an issue is if I give the mug to me to hold for me, and so
for your own benefit.
For my own benefit. So there's only one person in the whole equation, and that becomes a sham or a sham trust.
Now, when you say caretaker, my only inclination towards it, there are different legal arrangements. Yeah. Bailment is a typical example where I look for a caretaker in that sense. Yeah. in a typical trust, the legal title actually passes
Yeah.
to the third party. So, yes,
We're just looking at what the person actually does.
Yeah.
right. So in
Yeah.
function,
Yeah.
in function, you're a caretaker. But again,
In
because-
law-
in law,
You're the new owner.
You're the new
absolutely,
owner.
Yes, it's just that it is not, you're owning it on behalf of another.
absolutely.
And it's a kind of strange creation, because here in the trust, you are creating two owners. One is, in quotes, a legal owner,
Yes.
and the other is a beneficial or fairness or equitable owner. And the interesting thing is that even though you own it legally, the beneficial owner has rights that trump you.
To bring the conversation into context,
Yes.
perhaps let's ask, what would make an individual opt for a trust? So you talked about the historical antecedents of this whole creation,
Yeah.
which is people going to war.
Yeah.
You need somebody who probably is trustworthy, has the expertise, and is reliable enough to manage your assets till you come back,
Yeah.
especially because you don't know what the outcome would be. Today's modern world, we have other ways you can protect your assets. But why would somebody opt for a trust?
Okay. And I don't know whether I'm allowed to say this. You have a child out of wedlock,
Okay.
all right? And the missus doesn't know that you have this child out of wedlock. And your desire is that you would want to protect this child out of wedlock. So you would give assets to a third party to hold for this child until they come of age.
It's
That would-
interesting that this is the first example you went to. But yeah,
because
we are
I
here.
think that is what will resonate.
Whatever is being inferred,
When you say,
are your lawyers.
no, when he says that will resonate, it makes it worse. But
I think that will resonate in the minds of a lot of people. But beyond that, the reason why you would give an asset to a third party to hold for another party is because they might not have come into the age of majority. They might be a minor. And the law has restrictions on minors holding certain
you
assets.
cannot hold, for instance, landed
Landed
property
and
until you're
shared.
18.
Exactly.
So based on that, but I see people try to add their children's names to their deeds and their minors.
Yeah.
And those are not valid arrangements.
Okay.
So in such a situation, it's better to operate in a trust or
Yes.
to have somebody, basically
Yeah,
that.
so, I mean, in one instance, I had a gentleman who had a big property and wanted to share it between his wife and his daughter. So the wife became the trustee for the daughter's portion of the asset
Until
she attained the age of 25. And then that portion reverts to her. But there might be other reasons. So, for example, you're getting married and you're not sure whether the man is a gold digger or the woman is a gold digger. And you want to protect the asset that you're giving to your child from a messy divorce situation.
Yeah.
So the child can have the benefit of the asset depending on the type of trust you create, but not necessarily own it in totality. So they can have a life interest in the asset so that when they go, it can devolve to their children, that's the grandchild. It may also be that you have a child who has gambling debts or has attitudes and behaviors which do not inure to proper wealth management, and you want to protect that child. And so you would give it to the responsible adult who's the trustee, who will then hold it on behalf of the beneficiary. And needless to say, there are several types of trust.
I want to look at it from the angle of privacy.
Right.
Okay.
Right.
If you have a will, it has to be read.
Yeah.
Publications about it may come up.
Yeah.
And of course, the attendant challenges and all of that.
Yeah.
A trust gives you that privacy that endures even
Yeah.
after you have died.
Yes, yes.
Because
yes.
it's a setup you've put together. It's firmed up in a way that there's just continuity in that structure.
Okay, and in addition to privacy or confidentiality, you may want to set it up for tax efficiency. You may want to set it up for asset protection in terms of relationships. You may want to set it up so that you circumvent forced heirship. And by that, I mean you go around PNDC 111, you go around Sharia law. All of these things have impact on how you make distributions after death. So inter vivos, while you're alive, you can
see
say,
it in action.
You see what you want in action, and it can actually also give you flexibility in terms of distribution of the assets. So before we came on air, we talked about Harry and Meghan and said for some jurisdictions, you're taxed on your global income, for example, in America. And so if you are getting involved with a person who has American citizenship and you want to protect that asset, then you need to look at that.
Let's talk about how a trust actually works.
Yeah.
We've now captured, to some extent, the advantages or the reasons why people would opt for trusts from the potpourri of asset management opportunities.
Yeah.
How do they actually work?
Okay.
Yao started off by talking about a three-prong arrangement where there are three parties or players involved. But let's look at the actuals.
Okay,
in
so
as simple terms as possible.
At base level, I could give this cup to you.
Cup again.
Cup again. And
I want something bigger.
So I'll give you my pen and say, hold on to this pen for my son and for my wife. That is the basic arrangement. And then I will document that in a trust deed or a settlement.
Okay.
Okay, so you need to put it in writing. And of course, in our jurisdiction, we have the benefit of non-cupatory wills, oral wills. And so, or in Samansil as we call it. So you could actually create a trust in that sort of environment where you're on your deathbed and you need to give instructions. But beyond that, it needs to be formalized, documented, and stamped. Normally, you stamp it at Land Commission, pay stamp duty on it as evidence of what you intended to do. You can also, if you wanted a similar but easier route, insert it into your will. So by will, you could appoint your executors and say, I ask you to hold this on trust for XYZ until they reach a particular age of maturity. So those are primarily either verbal or oral non-cupatory, or in Samansil would be one route. Documented would be one route, and the other route would be the insertion in the will.
I think that in the structuring, in many sense, that the courts have determined that what they call the certainties, right? So in many sense, what a trust is, whether in any of the channels used, whether it's through a will or a full trust deed, or in the sense of Samansil or whatever, the court is almost always held that some certainties are important to make a determination of whether or not a trust exists. And the very first one is
so you're looking at the features that make a trust valid.
Valid, yes. The legal validity of whatever the channel's choosing, what makes it legally binding and a valid trust.
What must be there?
What must be there?
Certainty,
So the very first one is certainty of intention, or what they call words. So there must be clarity that the settlor or the person setting up the trust actually intended to set up a trust, right? And in many sense, that is where whether or not there was an intention of a gift, or there was an intention for somebody to be a trustee, all the legal argument around what was the nature of what the settlor really intended to do. If it's expressed in terms of the words, a trust, in sense of the wording, if it's clear and expressed, That is easier.
Yeah.
So that's the very first one, certainty of intention.
Yeah.
Now the second one is the subject.
Mm.
What is the subject matter of the conversation? And in many parts, that is a conversation of what am I seeking to put in the trust, right? So is it a property? Is it a shares of a business?
Yeah.
Is it the entire estate?
This is just money.
Or is it just money?
Yeah.
So there must be a subject matter for which reason the settlor is intending to put that property in the trust.
Yeah.
The last one, which is the object,
Yeah.
which is the beneficiary, is a very, very interesting one, because if you're looking at charitable trust, then that requirement, depending on the nature of the trust, may have different nuance.
Yeah.
But because it's an arrangement where you're passing legal title to one person and an equitable title to the third party,
Yeah.
that third party must be identifiable and known.
Yeah.
That third party or the beneficiary must be clearly determinable or determined,
Yeah.
as the case may be.
Yeah.
If it's a charity, then a class of people
Yeah.
for whom the benefit accrues to then must be obvious. So legally, these three things must exist, whatever the channel is.
To add to that, I think there's a fourth, which is timelines.
It must
When
not be-
does it terminate?
Right.
Okay, is it a revocable one also? Or is it irrevocable? Such that if it's irrevocable, you can change the terms as you go. But if it's revocable, you have that option like you would with a will
Right.
to make changes, to tweak it. I just think the trusts are there as an opportunity to make bespoke arrangements for
Thank
your
you.
assets.
That's
That's
And your,
a good use of language.
because
thank you very
it's
much.
you decide how it should go.
Yeah.
And you have that power to alter it. So you get to play God now
Yeah,
and
yeah.
even
then-
after
later.
you're
Yeah.
dead.
You can speak from the grave. But the classic situation that we're witnessing now is the war between Rupert Murdoch and his children. Rupert Murdoch and one of his
He
sons.
always has to draw from the international world.
Because it's an international law.
And
Yeah.
that is because he has significant wealth. He set up this trust, and it was irrevocable. And so he goes early this year seeking to tweak
The trust.
the trust.
And the
he lost.
beneficiaries
And the
are like,
beneficiaries
we wouldn't let you.
who said,
as
we
if
wouldn't
it's
let
their
you.
money.
Yeah. We wouldn't let you. And they went to court.
And they won.
Unfortunately, the beneficiaries won, and Rupert Murdoch lost.
It's important because you see, in classic legal precedents, the language of the intention must be clear and
Yeah.
irrevocable.
Yeah.
So, in many sense, if I'm intending to set up a trust,
Yep.
it is binding in the. If I am the trustee and I'm setting it for the benefit of my children, it would be, of course, there are exemptions where there are presumptions made, whether it's flowing from a child to a father. Those are different conversations. But
Yes.
naturally, for purposes of setting up a trust, because of the certainty of intention, there must be clarity around the fact that it's not revocable at will.
Yeah.
You know, otherwise, what happens to the benefit of the beneficiary? Because ultimately, they are the people who is set to benefit
I
from
think
the
it goes
asset.
more to intention than the
Yeah.
beneficiaries. Because for as long as you are alive, the beneficiary factor does not play.
Or
You
could-
still own the property.
Yeah.
It's about what did you intend to do. And this is
Yeah,
another classical situation
Yeah,
of the
yeah.
law is the law.
Yeah.
Where you opt for something that goes in the long run to affect you.
Yeah.
And although unfair, but that is how it is.
Yeah, and we saw it play out.
Yes.
Yeah.
We'll go for a quick break now. When we come back, we'll go back to the aspect of control and flexibility, which
Okay.
is still what we're discussing
Yes,
now.
yeah.
This is Law Express. Stay with us.
So the interesting thing is wanting to have control and yet wanting to give the gift away. And I see that quite a lot, that yes, I want to set up a trust, but I still want to control it. And in some jurisdictions, you can have an enforcer or protector. But generally speaking, with trusts, you're not supposed to have your cake and eat it. More to the point, some people will go to the extent of giving assets which they don't own absolutely. Now, that presents a problem. You know, from
before we go into actual ownership,
Yeah.
still on control.
Yeah.
The idea of the trust is not about controlling the day-to-day running.
No.
That control is unique, okay, to what your goals are. So you can only control the essence of the trust, but you do not get to control what everybody does on the daily,
Yeah.
as in your trustees.
Yeah.
So I think we need to draw this distinction.
So if I may try
Yeah.
and offer a perspective.
Yeah.
Now, if we understand that the legal title actually passes to the trustee,
There's a new owner.
Yeah.
New owner in what?
Yes.
More or less, yeah.
Now, the essence of whether or not the deed, if it's bound by a deed, sets some discretion for the trustee
To function.
or expressly determines the nature of the function, then becomes important.
Yeah.
In sense of how you determine control or
Yeah.
otherwise.
Yeah.
So, for purposes of setting up the trust, I am actually passing legal title, except that the beneficiary has an equitable title and can come against you, the legal owner, if you're doing anything to their detriment.
Yeah.
Yeah.
Having said that, so really in sense of law and who can have a fight over control is not even as much as the settlor, unless of course the settlor is the trustee himself. The settlor almost sets it up,
Yeah.
and unless he is the trustee, steps back,
Yeah.
and becomes a question of who the legal title is and who the beneficiary interest resides in. If a discretion is given for purposes of the management of the trust, then the trustee would have that liberties and the controls will reside. So usually, it's really the settlor. You are determining the use of the asset because you own it absolutely.
It's akin to shareholders who are not directors.
Yes.
Having the directors as the face of the entity,
Yeah. Yeah. Yeah.
and they are the people that will be sued, they are the people that take the day-to-day decisions, and you
Yeah.
just sit back
Yeah.
and monitor to be sure that what the essence is being followed.
Except that if you are a settlor, you're the giver or the grantor, and you are neither a trustee nor a beneficiary, then it means the bird has flown.
Yes.
You're
You have
done.
given it away, and save for maybe instructions about discretion and so on and so forth, you no longer have control and command.
But that
over
is
the
quite
asset.
rare. And that is quite rare, though, because most of them would still be in there as a beneficiary at least.
Okay, so what you see happening sometimes is you will have a parent or a grantor or settlor wanting, for example, to give houses away to children. They don't particularly need those houses, but they're very conscious that if the children have the houses, absolutely, they might fritter away the wealth. So in those instances, they do give it away, but it comes with conditionalities. Other times, you insert yourself into the story by becoming a beneficiary. So you cease being the
Especially
grantor.
where it's a going concern or
Yes,
commercial
yeah.
property.
Yeah.
Yes.
Then you insert yourself into the story, and you are always there in terms of being part of the story.
Mr. Albright, the
Yeah.
way you've summed this up just now
Yeah.
is it takes me to this idea where you're creating a trust out
Yes.
of a situation of distrust.
So typically, the rationale for setting up the trust is to avoid or enhance. So asset protection, confidentiality, like I said, tax mitigation. So there's either a prevention
Avoidance of
or
probate.
avoidance or an enhancement.
Yes.
Okay, and so the question should always be, for what reason? Is it a positive reason or a
Or-
negative reason that I'm setting up the trust?
It's important to mention that you cannot just solo take up matrimonial property and then set up a trust on your own without the consent of your spouse, because that property becomes something that is owned at the family level.
Yeah.
And once again, you can give what you don't have. You probably may be entitled to just a percentage.
And in fact, let me use this example. So, in many instances where people go for bank loans and they use their home or landed property as the asset, my first question is, are you married? Are you in a relationship? Because behind that relationship, there might be
some
an
rights,
equitable right to the property. So when you come to settle the asset, one of the questions that you need to ask is, are you married? Are you in a relationship? Do you have somebody living with you in respect of
or
this?
even is there any encumbrance on it?
Is there any encumbrance? Thank you very much. That's a more beautiful word. Is this asset encumbered in any way? So you, the lawyer, or you, the practitioner, need to ask that question. And you, the prospective settlor, also need to have in mind that if you have something that you share with a third party, then you can't go Nicodemously, surreptitiously to go and put it.
You cannot take family property to set up a trust. No. Especially where you are the one who is supposed to be the trustee of that family property.
Right.
And this is for the benefit of
and
everybody.
This is important.
Yeah.
So family, you're a trustee, whether the chief or family head, you're a trustee for the family.
Or the community.
So, yes. So in that sense, if you set a trust and pass
private
benefit
trusts.
on that, I think that to the extent that the contention can be on the ownership, the trust may fall through.
Okay, let me just also say that sometimes a trust can be a construction of law. For example, a constructive trust, where the courts determine that the nature of the relationship between you, the asset, and the potential beneficiaries is such that it is nothing but a trust, and they will call it a site.
So your brother built his home and asked you to watch it because he's take care of it, manage it because he probably doesn't live in Ghana.
Yeah.
And you now think that is a gift.
Yes. Yeah.
That was a trust arrangement.
Yes.
We've talked about the advantages of having a trust. We've talked about what would make somebody choose a trust as against other options. But nothing comes without the other side. Let's look at the disadvantages of setting up a trust, or what are the cons generally? Yes, not to say that trusts are bad, but what should you also affect your mind to as a cost?
Okay. I think in the conversation that has come up, because particularly you're passing a legal title to somebody in the middle, and again, backed by the history, in many sense, the people that the trust, that knights would give the property for users, began to assert legal right over it, which is why it evolved into a practice of law, and why the equitable remedy of trust was created by the Chancery. Because, for example, if it's a deed, and there's a house, and you've gone to sign the deed to a third party as a trustee for the benefit of your children, what if they assert the legal right in a way that defeats the benefit of it, the beneficiaries of it?
So a classic example would be you've transferred the house to the trustees, and then the trustees go and mortgage the house, as in Anglia Building Society.
Yes.
You know, and you wouldn't want that because what you see or what the other party might see would be the legal title,
yes,
but not necessarily the beneficial, the equitable interest underneath it. And so that risk exists. But there's also the issue of costs. You know, to be done properly, it is not cheap. And so,
if you could please hold your thought there on the cost, because this is a very important aspect of the conversation. We sampled people's opinion on today's discussion. Let's take a listen, and we continue with this other angle of the trust.
Okay, all right.
would rather keep my own money or manage my own money than giving it to someone else, because I have trust issues with human beings. So at times they can disappoint you and a whole lot. So instead of you giving your money to someone else to manage it for you, I think it would be rather better for you to manage it yourself. Yeah.
Putting my money in a trust is quite a no-no for me because of the whole stress going to bank, the queue and all that. Sometimes internet connectivity is quite poor. So I would prefer having my money on me, is either in my Momo wallet or maybe physical cash. I don't do banks.
So I have heard of trust before, and it's associated with banking, basically a banking terminology. And it has to do with a legal contract between two people. That's a grantor and a trustee. The grantor gives out assets to a trustee based on legal conditions for the advantage of people who benefit from that assets.
I think that there's a comment that I want to comment on, which is the idea that banks and other those arrangements are trust arrangements. They are not exactly trust, except that they bear something in common, which is fiduciary relationship with what a trustee is. So typically, the closest business arrangement you probably can say is a pure trust is the pensions agreement, because a trustee, and they are actually called trustees. So the pensions trustee is actually a trustee.
You send in money for them to manage for you.
Absolutely.
For your benefits later.
When you go for pension.
Yeah.
So the pensions business, you can say, is a trusteeship business. But a bank is typically, you lend money to the bank. Yeah. The money, as it is typically a loan you've given to the bank, on which they make you a promise to pay whenever you call on them. Yeah. So the nature of that arrangement is not exactly a trust, except that they are fiduciaries as much as a trustee is.
They have some features in common.
Yes, they have features in common, but it's not guided by the same arrangement. So I thought that was important to clarify. Yeah.
Before we went for Vox Pop, we're looking at some of the disadvantages of setting up a trust.
Yeah.
You started on cost.
Okay, let me start with loss of control.
Okay.
All right. Loss of control means that ultimately you're giving the asset away. You are determining to some extent how you want the asset to be managed post settlement, but you may lose control, as in the case of Rupert Murdoch and his children. So that is one. But the other thing, elephant in the room, which we need to deal with, is that sometimes trust can be complicated, especially where there's significant...
Most times, because it's the wealthy who normally look at it.
Yeah, where there's significant wealth, it can be very complex. And
especially cross-border wealth.
I was just going to say, so you can have the trust set up in Ghana, and then you can have the trustees sitting in China, and then you can have the assets sitting in America, and you can have the beneficiaries sitting in Japan. Everywhere else around the world. So that can be quite complex, and then sometimes the beneficiaries can, the assets can be companies, and then beneath them you have different
There
asset
could be
classes.
complexity also, like we said just now, the nature of the assets.
The nature of the asset.
Is it Bitcoin?
So it could be cryptocurrency.
Yeah, exactly.
It could be trademarks, image rights. It could be blood stock. It could be shares. It could be coins, wine, horses, art. I haven't talked about shares and businesses and so on.
Yeah.
So all of these assets, different asset classes, can be embedded within the trust. And then the trustees will have responsibility for managing all of
they
these.
have to be people who understand the management of these kind of assets to qualify, because they will have to be paid for the service.
They get paid for the service. And here's the third arm, which is the issue of costs. Quite frequently, I have clients come to see me say, Theodore, I want to set up a trust. That's fine. But then when you look at the setup costs and the annual fees involved. And the fact that the more activity in or under the trust, the more, the higher the fees will go. So settlement trusts, where there's significant wealth, should not be taken lightly.
Especially where you already have businesses, going concerns. You have a structure, there are people working there already. Then you have another trust that is to oversee what the people you already pay currently are doing.
So typically with that, if it's a company, the shares that will float up, maybe even to a holding company, if there are several companies, and then above the holding company will sit the trust.
But you need to look at monitoring, declaration of dividends and all of that. So that is the context that I was looking at it. Let's go for another break. When we come back, we still need to discuss the costs in respect of even drafting of the complicated document or instrument you need to operate a trust. Stay tuned.
Okay, so for purposes of cost, particularly for the lawyer helping structure the trust, there are basically three elements to look out for in terms of the nature of the cost. The very first clear one is the value of the assets in discussion. Based on the nature of what values are in the trust, the lawyer may make a determination of a percentage of the value of the assets in issue. The second one is based on the complexity. So if the trust is a convoluted, complex arrangement, then of course that will go into the pricing and the idea of it. And the last consideration is the time. How much hours, man hours is the lawyer and the law firm pouring into making sure that the trust works well and is effective for the purposes of the beneficiary. So I may not be able to speak to a specific figure, but at least it gives us a sense of, based on what I'm dealing with, whether in complexities or in terms of the values we're talking of, or the sheer amount of time devoted to the arrangement. Then
lawyers and complexity. What you're saying is you either value the asset, that will be in the trust, and strike a percentage as your legal fee.
Yes.
Or you bill according to the number of hours you dedicate.
Yes.
You mentioned the issue of complexity. That's reads or would affect the timelines. The more complex, the more time you need to put in. You may need to bring in other experts to help with the arrangements. There's a transfer involved, so the cost is not just about legal fees. There's a tax bit. And of course, legwork, you need to coordinate, get the various officers to do the needful. So all that builds into the cost.
Okay, so
and the running costs.
So typically, when the client comes in, they have this notion that they want to have the trust in a particular jurisdiction. And immediately it means you need to get tax advice for Ghana and tax advice for the jurisdiction. Because you don't want a situation where the client gets taxed twice. Then it'll be a disaster. Beyond that, once you've gotten the tax advice, you also need to get quotes and advice from different jurisdictions, because each jurisdiction will treat the trust differently. Then beyond that, of course, you've got the fees for the trustee and whether, in fact, you're creating a trust or you're creating what you call a PTC, a private trust company. In that case, you're actually creating a company to manage your trust. And then you employ another trust firm to manage the company to manage your trust. So it can be quite complicated and convoluted. And of course, where the value of the assets are significant, then the rationale for charging a percentage is because, simply put, indemnity, liability. Should the arrangement go wrong for a $20 million estate, the settlor will come at you asking for $20 million. If you only charge 100 cedis, you're dead.
I think we already discussed the overhead cost.
Yeah, and of course,
running it.
The running.
The running.
Mentioned that earlier. Yeah.
And remember, I gave the example of having the assets in Ghana, the persons in South Africa, the trustees in Japan, the beneficiaries in Singapore, for example. Immediately, what you have is a convoluted structure.
An army of people.
An army of people, and that becomes quite complicated. Add on, and this is really critical. When a person walks through the door, I normally ask them what passports they hold.
Yeah.
If you hold a Ghanaian passport, fine. If you hold a Ghanaian passport and a British passport, the question then is, where are you domiciled? Where are you permanently resident? For tax purposes,
Yes.
Britain will tax you 40% on your assets. Okay? If you're American, then income tax purposes, there's an issue. So, as the person walks through the door, ask them how many passports they hold and how many passports their children and their spouses and beneficiaries
In a
hold.
nutshell, it's better to always have a legal expert
Absolutely.
involved in the creation
Absolutely.
of
It's
a
interesting,
trust.
the chorus of absolutely. Because, you know, it's even the nuance of it requires that you need some expertise around
Yeah.
it.
This is a great time to consider a few questions coming in by way of social media
Okay.
on this topic.
Okay.
We'll try to resolve that. But then I would want us to look at, just like every other instrument that takes care of people's assets beyond the grave, trust could also bring issues of conflict.
Yeah.
So we will look at that as one of the cons
Right.
after our social media discussions.
Okay.
Hello, Noella and the Law Express team. Thank you for introducing such an important topic. I am a married man with a young family, and I'm watching the show from Takrade. I keep hearing people talking about setting up a trust, but honestly, I don't understand why it's something I should be thinking about. I don't consider myself wealthy. So is it really necessary for someone like me to create a trust? What would be the point?
Yeah, so I would say that that in 2 or 3 instances, they're already in a trust relationship. And the first instance will be in their Tier 2 pension scheme and their Tier 3 pension scheme. And then any benefit that they stand to receive from their employer. Because once you go into employment, you're normally asked, who is your nominated beneficiary?
Next of kin.
Next of kin. And in that instance, or in insurance, in that instance, you've got an active trust relationship. Beyond that, yes, he's right. If he doesn't have significant wealth, then there's no need to go through all of that process. A simple will suffice.
Absolutely.
That would be my
Yeah, so just on that, and that was the point I was going to make. A simple will, but if even you're inclined to have a trust, you can have a simple trust arrangement in the will for the benefit of the children. So particularly in his case, assuming you have a personal property which you want your children to benefit from, but in giving it to, say, your wife, you're not sure whether another man will marry if you're not around. Another man she marries will now have an interest in the property. And if you want to avoid all of that, you want to create a trust on the property for your children with your wife as a trustee.
And I have a story. I always have a story where wife has 4 children, husband has 1 child. They come together and they do what we call mirror wills. Okay, but there wasn't a trust arrangement. So wife dies first, and then husband now disinherit the children, the 4 children of the wife, simply because there was some argy-bargy between husband, stepfather, and the children. And all the wife's assets ended up with the man's son upon his death. Okay, so here, clearly, the wife could have said, I want my husband to hold the items, the assets in trust for my children, or have a life interest,
Absolutely.
which then devolves to the children. So it's really important.
I think what the questioner should look at is the essence of his property management. Is it that you do not want to lose control? Is it that you don't want to lose the property? Or it is that you want to exclude somebody from dealing with your property? It will give you that chance to now evaluate with an expert to figure out how you can achieve your aim without necessarily using the trust if you do not have the funds to take care of that.
So if you don't want PNDC 111 to work and affect your assets, then and you think a trust is too expensive because your asset is not, then you should be taking legal advice with a view to
Yao also mentioned you could still have something that looks like a trust, but not in the manner that we have been discussing.
That's correct.
Not a complex trust.
No, not complex.
You can let somebody, it could even be your lawyer, hold it in trust for your kids for a period.
Absolutely.
My name is Joey, watching from East Legon. I'm a young man with a promising career, and I'm beginning to put my finances and future in order. At what point should someone like me start thinking about setting up a trust? Is it something to look into early on, or only when you've built substantial wealth or have dependents?
Of course, we've been saying that you must be an absolute owner to be a settlor. So, of course, you need some assets, you need some ownership to set a trust ongoing. But it doesn't mean you need all the wealth in the world in order to think about a trust. My clear advice to him is keep on doing what you're doing, keep on building the wealth you're building. But as you do it, have a clear conversation to how do I make a determination of the running of the assets in the most efficient way? In thinking of all the tools available to you in managing the wealth or the assets you have, a trust is one of the tools you can use in managing whatever wealth you've acquired.
And of course, cost-benefit analysis. So if it's a car, is it worth my while setting up a trust? But if it's $100 million, is it worth me setting up a trust? And sometimes a driver for setting up such a vehicle might be your value system. I have clients who have certain values, and those values they want to enshrine and make sure that it transcends generations. And because of that, they allow the assets to go into vehicles to enable those values to be upheld. So really important.
No, that's a very interesting point, because you see, in many sense, particularly when you begin to talk about public trusts and trust set up for charitable causes and things like that, it almost hinges back to values, right? Because you're making a choice for a determination of whether education or poverty or whatever,
religion,
or religion or whatever the case may be. So the whole notion around public trust is some values underwritten. On the private side, not exactly so. On the private side, what you're making a determination for is a benefit of an estate or property for a third party.
Except that sometimes, like Rupert Murdoch's situation, where he sees that actually only one son has his values, conservative values, and the remaining 4 children do not share his values. And that was the rationale for going back to seek to tweak the arrangement. Because the favored son was going to hold the line, but the others were too liberal for him. And for that reason, he wanted to tweak how they arrange across generations.
I'm just listening because it looks like we are already in that space of the potential conflicts.
Yeah.
And that's what we've been discussing.
Yeah,
I
yeah.
wouldn't have to prompt that aspect of the conversation. But having a trust does not insulate you from potential conflict, just as a will can be challenged and contested.
Yeah.
Trust too could bring issues, especially it could be between trustees and beneficiaries.
Yes.
It could be like the settlor and beneficiaries. It could be everybody fighting everybody because of fairness. So once again, you have elected to set up this machine in motion, and once the horses leave the stable, it's almost impossible to call it back. You have created a sense of entitlement by making somebody a beneficiary in something perhaps they never would have dreamt of having. And now it's almost impossible to take back and rewrite that, especially in the situation of an irrevocable trust.
And so for that reason, in certain sophisticated jurisdictions, they would have something like what you would call a protector or an enforcer. And that person will not necessarily be the settlor, but written into the trust instrument will be that they need to take instructions from the enforcer or the protector. Add to that, you can have what you call letter of wishes, which are backdoor instructions given to the trustees.
Like a manual.
It's a manual to say, you shall do this, thou shalt not do this.
So these are like the 10 commandments
These are the
of
10
the
commandments.
trust, and you can touch those.
And so those help to manage. So for those who want a trust but don't have control or want to have a measure of control, the enforcer type trust or the protector type trust or the letter of wishes.
That is if you know early enough
That's
to
why you
put
need
all those in.
That's why you need to speak to your sophisticated lawyer.
Very well. It's time for the last break. We'll go for a last break and then we come in to wrap up this conversation.
No problem at all. So ultimately, the trust will last for a long time, and often it will last beyond the tenure of the first and the second generation. So inbuilt within the trust deed will be instructions as to how to perpetuate the use of the trust. In some cases, depending on the jurisdiction, the trust will be wrapped up either 99 years or 120 years. In some jurisdictions, it's a perpetual trust. Where there's significant wealth, then normally you want it to run in perpetuity.
Right. I think that the ultimate point for me is that we need to think about trust as an instrument for use a bit more as a people. And we need to consider it as a wealth management tool that needs to be contemplated on a bit more. From both the practice and the use of the client. And so it's really good you're having this conversation. All of us at least are aware of the use of it and are aware of the opportunity to use it. And if we can all build a bit more understanding of what this instrument is and mainstream its practice and use, I think that we'll move estate management beyond Wales slightly up to utility that goes beyond one generation.
Can I just step in very briefly? One of the reasons why I came to Ghana was because a certain president said Ghana was going to be an offshore jurisdiction. And that made me really happy. Unfortunately, we don't see...
So without more, you just packed your bag?
No. But unfortunately, we never built the systems, including trust, corporate, and so on. But that could be a potential earner.
I think it's a
Ghana.
function of us not having enough laws to regulate trust in Ghana. We are working with the common law, British law, and Yeah, that's it.
Yeah.
Yes, it's part of our law,
Yep.
but it's probably time to
Yep.
have our own trust
agree with you.
arrangements.
I agree with
And
you.
probably we could start this conversation of
I agree
lobbying
with you.
to have
I
that
completely
done.
agree
Yeah.
with you.
You know, this is one of those conversations where we could never quite wrap up conclusively because there's a lot more to discuss on this subject matter. Perhaps we could have a second run of this episode to have a part 2 of trust.
Yeah.
But to conclude, not every solution or avenue available to you might suit your situation. We're looking at managing people's estates and wealth, but it does not mean that trusts are suitable for every person who is rich. You might want to consider others, and that is why you need to talk to an expert at every given time. And that is why Law Express always recommends that. Talk to a lawyer. This has been our show. My name is Noella Seidu. I was joined today by Theodore Kwaku Albright, and of course, once again, by Inshiraba Yao Sumpa Autry. Thank you very much for being with us. Goodbye till next time.